Good day. I am Boer van der Eems, Chairman of the Pestallozzi Trust. The Pestallozzi Trust was invited to do a presentation on the Basic Education Laws Amendment Bill, or the so-called BELA Bill, on the 15th of November to the Portfolio Committee of Basic Education. For your information, and so that parents can understand what is at stake for homeschoolers in BELA Bill, I'm doing this recording of the presentation that was done at Parliament on the 15th of November. In this presentation, I will refer to Clause 37 of BELA Bill. It is this clause that has got impact on home education, and it requires that homeschoolers should follow the national curriculum and should be monitored by the Department of Education. It also requires home visits to homeschooling families. It gives the ministers unfettered regulatory power over home education and is increasing the penalty clause. I'm going to share my screen now so you can see the presentation. In the SA Schools Act, 60 sections are about schools. One is about home education. Why is it there? Why should it stay there? I am Boer van der Eems, Chairman of the Pestallozzi Trust and a homeschooling father of 5. For the presentation at the PCBE, I was also joined by a number of delegates that joined me in the Q&A session after the presentation. These delegates were Karen van Oostrum, Lebohang Nobo, Lita van der Eems, Neresh Badal, and Sean Green. The Pestalozzi Trust is a civil rights organization for home and civil education. It was established in 1998 to protect the rights and freedoms of families to educate their children at home according to their own religious and/or philosophical persuasions and cultural traditions. The position of the Pestalozzi Trust is that Clause 37 should be removed from the BELA Bill. Accountability should be based on a law designed to regulate home education in a fair way, based on research with meaningful consultation. This presentation discusses 3 questions. Why do parents not want Clause 37? Why does the minister want Clause 37? What now? The first section will describe why home educators do not want Clause 37. Firstly, most parents are concerned that the BELA Bill prescribes the curriculum that parents must choose. A. The amended Section 51 requires that the head of department must be satisfied, and I quote, "The proposed home education program covers the acquisition of contents and skills at least comparable to the relevant national curriculum." Whereas the preamble of the SA Schools Act states that it's necessary to set uniform norms and standards, the BELA Bill replaces this with contents and skills. Contents and skills on the one side and standards on the other side are different things. B. The amended Section 51 also requires that parents must, quote, "arrange for the learner's educational attainment to be assessed by a competent assessor annually. These assessors must be registered with the South African Council for Educators, or SACWA. Will these assessors be capable to assess the diversity of curriculums that homeschoolers use? Why were professionals that are capable of doing curriculum independent assessment, such as educational psychologists, excluded in the definition of competent assessors. C. To add insult to injury, parents are required to pay for these competent assessors, which could make home education unaffordable for some parents. To make things even worse, the socio-economic impact assessment for the BELA Bill does not consider these costs of these assessments, and the public could not assess the impact when the bill was published for comment. Secondly, many home educators object to unfettered powers given to the education officials to invade the private homes of families. Section 51 of BELA Bill states, the head of department may require a delegated official to conduct a pre-registration home education site visit. The policy on home education, however, states that an official must make a home visit. The policy makes the intention clear. The intention of home visits is to intrude in every single home without limitations of what officials can do. The Pestallozzi Trust submitted a legal opinion to the Office of the Chief State Law Advisor. The opinion argues that to allow home visits constitutes an unjustifiable limitation of the right to privacy. Chances are good that this may lead to a legal challenge. Section 51(16) of BELA Bill reads, the minister may make regulations relating to the registration for and the administration of home education. The terms registration and administration are broad. There is no reason to believe that these terms will in any way limit the matters on which the minister can make regulations. With unfettered regulatory power, the minister can make home education impossible over time. The fourth problem is the penalty clause. The Pestallozzi Trust obtained a criminological opinion on the penalty clause by a criminologist. The main points of this opinion are: the nature of the offence is one of administrative neglect. When parents that can prove by a variety of means that the child is receiving quality education fail to register. Imprisonment and an unlimited fine will have disastrous effects on a family, making it permanently impossible to meet even the most basic needs of children. This cannot be in the best interest of children. The Pestallozzi Trust also obtained a legal opinion on the penalty clause by advocate Sarah Padaffin-Jones. I quote some main points. 1. There can be no doubt that the removal of a parent from the life of the child through imprisonment for up to a year violates numerous rights of a child, including the right to family care in Section 28 of the Constitution. There is also no evidence that the increase of the penalty will be an effective deterrent. In fact, the evidence points the other way. UNESCO concluded that no substantial evidence exists that a punitive approach to learner absenteeism works. What was clear, however, was that penalizing truancy operates disproportionately harshly on poor families. The BELA Bill makes the home education movement believe that they are reliving the past. The apartheid government used imprisonment to enforce school attendance against the religious convictions of the parents in the 1990s. This article is about the Mainkies homeschool family of Van der Bijl Park that were imprisoned and their children were placed in orphanages far from home, just because they didn't send their children to school. The next section will now deal with why the minister wants Clause 37. Understanding the why of BELA Bill is essential for meaningful collaboration and mutual trust. This is only possible if the parties share a common purpose and agree on the facts obtained through independent research. Firstly, the purpose of the South African Schools Act is articulated in the preamble, which states that it aims to establish a, and I quote, a new national system for schools and, quote, set uniform norms and standards for the evaluation of learners at schools. The preamble of SASSA is not changed by the BELA Bill. Therefore, the purpose of SASSA remains the same. Clause 37 of BELA Bill, however, has nothing to do with the purpose of SASSA, because home education happens outside the school system. Therefore, the preamble gives no clearly articulated common purpose for Clause 37. The Pestalozzi Trust repeatedly asked for a purpose statement for the home education amendments, but never got a cogent response. However, a record of decision of the home education policy obtained through a PAJA application revealed a number of concerning statements. The first statement is from a WITS EPU paper, quoted in an Umalusi report on home education in 2010, and states, quote, the only option for parents who do not want their children to be taught the national curriculum is to leave the country or send their children for education abroad. This gives an idea of how Umalusi interpreted the current SA Schools Act. For Umalusi, there does not seem to be any lack of clarity. The second statement refers to issues raised during a CHEM meeting. CHEM is the Council of Education Ministers, which consists of the national ministers and all the provincial MECs, a CHEM meeting of 2017. One of these is, quote, the implication of scrapping the home education should be explored. Fortunately, officials informed the MECs that home education is legal and cannot be scrapped. It does, however, give insight into the wishes of the education establishment. If home education cannot be scrapped, then the next best option is to make the registration requirement so stringent that it makes home education impossible. The third statement confirms this. In the socio-economic impact assessment for the home education policy, it states, senior management also recommended stringent measures that will make it not easy for parents to opt for home education. Whereas the apartheid government made home education illegal, the education establishment wants to use registration requirements to make home education impossible. Is collaboration and mutual trust possible if this is the intention of the minister? Secondly, collaboration also requires mutually agreed facts obtained through research. The minister made a good start in 2012 by appointing Dr. Trevor Coombe, former Deputy Director General at the DBE, to compile a discussion document on home education. The final draft of this document states, A comprehensive understanding of the home education phenomenon in South Africa can be achieved only after an independent research study has been carried out on the basis of a research design in which both the departments and the home education bodies have confidence. Until reliable information is available, the development of a new home education policies and amendments to home education law should be approached with due circumspection. The draft discussion document was never published for comment, as promised by the Minister in 2012 in response to a question in Parliament. In response to a question by Honourable Soekers at the PCBE on 8 February 2022, the Minister said, when asked if the DBE has done any research into home education, and I quote, "We have not done any research." The Pestalozzi Trust, however, commissioned its own research and submitted this as input to the Socio-Economic Impact Assessment, also known as SEIA, for the BELA Bill. No response was received on this, and neither does the SEIA refer to this research. It seems that the DBE failed to provide this to the presidency that compiled the SEIA. Thirdly, a number of procedural flaws in the drafting of BELA Bill made meaningful engagement difficult. When the BELA Bill was published in 2017 for public comment, the Socio-Economic Impact Assessment, or SEIA, was not published with the bill as required by the guidelines of the Department of Planning, Monitoring and Evaluation. When the BELA Bill was published for public comment in 2022, the SEIA was again not published with the bill. This means that the public was expected to comment without understanding the social and economic impact of the bill. Although the SEIA was not published, the Pestallozzi Trust obtained the SEIA of the latest BELA Bill from the DBE after a prior request in 2021. The SEIA is, however, severely flawed in its impact assessment of home education. These procedural flaws could provide strong grounds for a legal challenge. In summary, parents will resist prescription of curriculum, assessment, and home visits. This will lead to conflict and litigation. This is not merely an abstract prediction, but current reality. There is currently active litigation between home educators and the KZN MEC. Secondly, Clause 37 has no articulated purpose or basis in research, making mutual trust and collaboration impossible. The Pestalozzi Trust recommends that Parliament does not accept Clause 37 of BELA Bill and recommends a new road on home education. This new road is explained in the next slide. The Pestalozzi Trust does not only want to criticize, but also wants to collaborate on developing a roadmap towards a better regulatory framework. Principles of such a framework are: A fair regulatory framework requires that the roles of player and referees must be split. Currently, the provincial education departments operate public schools in South Africa and are therefore dominant players in the education sector. However, officials from those provincial education departments must also administer the home education provision in the Act. They are therefore adjudicators that have to give permission to parents to home educate. Therefore, the education departments are players and referees in the education sector, which is unfair. Secondly, an appropriate regulatory framework requires that the law used to regulate something must be designed for the thing it regulates. According to its preamble, the SA Schools Act was designed to regulate schools. However, home education is fundamentally different from school education. Therefore, home education is regulated by a law not designed for home education. It is like regulating bicycle transport by means of a Trains Act. Thirdly, the education landscape has significantly changed over the last decades. Apart from home education, there has been an exponential growth of a number of emerging education modalities. Modalities such as cottage schools, online schools, tutor centers, collaborative home education, and co-work spaces. Home education and these new modalities are interrelated and interdependent. Regulatory reform of one of these modalities cannot be done in isolation. Fourthly, without mutually agreed research, collaboration will be impossible. And fifthly, the National Education Policy Act, or NEPA, prescribes the bodies that the minister must consult before determining legislation. Currently, NEPA does not make provision for consultative bodies for home educators. NEPA must therefore be adapted to make new provisions for other forms of education. In closing, if BELA Bill remains as it is, the road forward will be one of conflict and litigation. However, creating a new dispensation that allows emerging education modalities to flourish will create a laboratory where new methods can be developed that can also benefit the school sector. The pandemic gave us an excellent example. I thank you for your attention. Thank you very much. This was the end of the presentation that was given to the PCBE. Afterwards, there was a Q&A session. If you want to listen to the recordings of this presentation, they are available on the website of the PMDG, the Parliamentary Monitoring Group. Thank you very much, and I hope this presentation helped to give you an insight on what's at stake with the BELA Bill. Goodbye.